Hey, this is Angela, and you're listening to the Study for the Bar in Your Car podcast. This is the podcast where we use me and my notes, but mostly we use AI to delve into bar topics. So, as you know, it works like this. I've taken the bar a few times, and I've got lots of notes from taking the bar exam. So I've taken those notes from my bar studies, so notes that I've done and also outlines that I've done. This is like hundreds, maybe even thousands of pages. And I've put them into AI, and I have the AI generate the podcast. So now we have this podcast with these two hosts, a male voice and a female voice. I call them Ma and Claude. And it's really fantastic what they can do. Now, AI isn't always perfect. And in fact, for this episode, which is a wrap up of all of civil procedure, I had to redo it because I listened to the first one and I'm like, they got a few things not quite right. So I had to readjust my notes and then re-upload it and then regenerate the podcast. So what you'll be listening to is version 2 of the wrap up of civil procedure. Version 1 is going in the circular file forever. So I hope you enjoy this. And as you know, AI isn't always correct, but I have put in some quality control and I have tried to make some corrections here. And it was, I wouldn't say it was like a lot of big corrections that I needed to make, but I just had to regenerate the whole podcast in order to affect the corrections. So if you need to reach me, you can reach me at podcast@studyforthebarinyourcar.com. I'm also a law clerk. I work freelance for attorneys all over the country. So if you're an attorney or you know an attorney who needs an extra set of hands, someone to write motions, someone to jump in and do some pre-trial work, you can reach me at legalwriterandlawclerk.com. Anyhow, take it away, Ma and Claude. Bring us home for civil procedure.
This is the Study for the Bar in Your Car podcast.
Hello, everyone.
We're your hosts, Ma and Claude. And today, we're tackling a big one. We're wrapping up our deep dive into civil procedure.
That's right. And we have some fantastic material to work with.
We absolutely do. A huge thank you to Angela. She's a real person, an LLM law student who shared her incredibly detailed law school notes with us. Seriously, thank you, Angela.
Yes, Angela's notes are just phenomenal. And, she brings a really practical perspective. She was a judicial law clerk for a mass torts and complex litigation center. So she's seen these rules in action day in, day out.
Ah, that makes sense.
And she apparently did quite well in Civ Pro for the bar exam. So these notes really focus on what's critical and maybe where the pitfalls are.
Perfect. So that's our mission today, a focused deep dive using Angela's outline to hit those key Civ Pro concepts you really need to nail down. We want you to feel solid on this before we pivot to contracts next time.
Exactly. We're going to walk through, jurisdiction and venue, how federal courts figure out which law to apply, the whole pretrial maze, like pleadings, joinder, discovery, then jury trials, motions, big topic there, verdicts, judgments, and finally, appeals.
It really is the whole life cycle of a case, from filing to final review.
Pretty much foundational stuff.
Okay, let's jump in. First, big hurdle, jurisdiction and venue. You need both.
Okay.
Court needs the power, that's jurisdiction, and it needs to be the right place, that's venue.
Precisely. And jurisdiction, well, it breaks down into personal jurisdiction, PJ, and subject matter jurisdiction, SMJ. PJ is about the court's power over the defendant, the person or company you're suing.
And Angela's notes say you need two things for PJ. Some kind of statutory authorization.
Yep, like a state long-arm statute.
Yep.
California's is famously broad, basically goes right up to the constitutional limit. Or sometimes a federal rule, like Rule 4K.
And it has to meet the constitutional standard, due process.
Yeah.
Which means minimum contact.
Minimum contacts. That's the core constitutional test. The defendant needs to have certain minimum contacts with the forum state so that the suit doesn't offend, traditional notions of fair play and substantial justice.
Okay, minimum contacts. But it's not just any contact. The notes really stress purposeful availment. The defendant had to deliberately reach out to the state.
Exactly. Targeting customers there, selling products there that's purposeful, just changing planes at the airport? Yeah. Usually not.
Unless you get served while you're physically in that airport. Whoa.
Slight chuckle. Yeah, the old transient jurisdiction trick. As long as you weren't tricked or forced there, being served while physically present generally works for PJ, even without other contacts. Classic trap.
Okay, so purposeful availment first. Then, relatedness. Does the lawsuit actually arise from those contacts?
Right. If it does, that's specific jurisdiction. And Angela's notes point out, even one single contact might be enough if the claim directly arises from it. The car accident example is perfect. You drive in the state, crash, the claim arises from that driving contact.
But the vacationing trustee example. Trustee from New York is in Florida, gets sued in Florida about trust stuff back in New York. The vacation contact isn't related to the trust claim. So no specific jurisdiction from just being on vacation there.
Correct. Now, if the claim doesn't arise from the contacts, you need general jurisdiction. This means the defendant's connections are so continuous and systematic that they're essentially at home in the state.
At home.
And if they're at home, they can be sued there on any claim, even one totally unrelated to their activities in that state.
And for corporations, Angela's notes pinpoint the two main places they're at home, state of incorporation, and their principal place of business, the nerve center where the executives direct everything.
Those are the reliable anchors. The Supreme Court left the door slightly ajar for exceptional cases, but realistically, those are the two you count on for general jurisdiction over corporations.
Okay, but even with contacts and relatedness, there's one more check. Fair play and substantial justice.
Yes. Even if minimum contacts exist, jurisdiction has to be fair. The court looks at the burden on the defendant, the state's interest in the case, the plaintiff's interest, efficiency, that kind of thing.
Angela's notes mention Asahi, Japanese company, component part. Too much burden, not enough state interest after the main plaintiff dropped out.
Exactly. Contrast that with, say, McGee v. International Life Insurance. California insurer solicited one policy in California, beneficiary sued there. Court said that was fair, strong state interest. Defendant reached into the state.
Got it. Okay, that's PJ. Who? Now, subject matter jurisdiction, SMJ power over the type of case. And the big takeaway here, federal courts have limited SMJ.
Hugely important. They can only hear cases Congress or the Constitution says they can, and unlike PJ, SMJ cannot be waived. Cannot be waived.
Parties can't agree to it. And the court must dismiss, even on its own sua sponte, if it realizes it lacks SMJ. Even on appeal. A massive difference from PJ.
So what kinds of cases can federal courts hear? Angela's notes list two main ways: federal question and diversity. Federal question, or FQ, is when the claim arises under federal law. The easy way is the creation test. A federal statute creates your right to sue, like suing under the Federal Tort Claims Act.
But then there's that trickier one, the embedded federal issue, from Grapple.
Right. This is where your claim is created by state law, but winning it necessarily requires proving an issue of federal law. That federal issue has to be actually disputed, substantial to the federal system, and resolving it in federal court shouldn't disrupt the state-federal balance.
The notes contrast Grapple with Merrill Dow, where the federal standard came from a law that didn't allow private lawsuits. So the embedded issue wasn't seen as substantial enough for FQ. Kind of subtle.
Very subtle. Okay, the other big basis for SMJ, diversity jurisdiction. Two requirements here.
Citizens of different states, and the amount in controversy has to be over $75,000.
And for the citizens of different states part, the key is complete diversity. No plaintiff can be from the same state as any defendant.
Citizenship rules. Individuals, it's domicile, where you live and intend to stay. Corporations, it's two places, where they're incorporated and their principal place of business, the nerve center.
And watch out for LLCs. Angela's notes flag this. An LLC has the citizenship of all its members. So one member from the plaintiff's state, boom, diversity is destroyed.
Ouch. Okay, what about permanent resident aliens?
For diversity purposes, they're treated as citizens of the state where they are domiciled.
And in the amount. Over 75Ks. Plaintiff's good faith claim usually controls, right? Unless it's like legally impossible to recover that much.
Correct. Aggregation rules apply too. One plaintiff can add up all claims against one defendant. But generally, multiple plaintiffs can't add their claims together, nor can you usually add claims against multiple defendants to reach the 75K unless they're jointly liable.
And Angela's notes mention exceptions. Federal courts usually stay out of divorce, alimony, child custody, and probate cases.
Yeah, the domestic relations and probate exceptions. Even if diversity technically exists, federal courts generally decline those cases.
Okay, so if a claim doesn't have FQ or diversity on its own, can it still get into federal court? supplemental jurisdiction.
Yes, under 28 U.S.C. Section 1367. If a claim is so related to a claim that does have federal SMJ that they form part of the same case or controversy, usually meaning they arise from a common nucleus of operative fact, the federal court can hear the state claim too.
Section 1367A grants this power.
But Section 1367B takes it away in certain situations and only in diversity cases. This is a major testing area.
Right, the restrictions. It mostly limits claims by original plaintiffs against parties brought in under rules like 14, 19, 20, or 24, or claims by people trying to intervene as plaintiffs or who are joined as required parties under Rule 19, if adding that claim would destroy complete diversity.
So let's say you, the plaintiff, sue a diverse defendant. Then you want to add a second non-diverse defendant under Rule 20, asserting only a state law claim against them. 1367B likely blocks supplemental jurisdiction over that specific claim because you're the original plaintiff, adding a claim against a Rule 20 party, and it kills diversity.
Makes sense. Keeps plaintiffs from sneaking around the complete diversity rule using Joinder.
Pretty much. And even if 1367A allows and 1367B doesn't restrict, the court still has discretion under 1367C to decline supplemental jurisdiction. Maybe the state law issue is novel or complex, or the state claims dominate, or the main federal claim gets dismissed early.
Got it. And one last jurisdiction type mentioned, quasi-in rem. Based on property.
Yeah, based on property in the state, but the suit isn't about the property. Nowadays, you still need minimum contacts for this. The judgment only affects the property itself.
Okay, jurisdiction sorted. Now, service of process. Actually telling the defendant they're sued. Angela's notes say this is crucial. No proper service, no valid PJ, judgment is void, even if they know about the suit.
Absolutely critical. Federal Rule 4 governs this. It allows service using the methods permitted by state law where the federal court sits or where service is made.
For individuals, you can do personal delivery, leave it at their house with someone suitable who lives there, serve an authorized agent.
For corporations, you can serve an officer, a managing or general agent, or again, follow state law methods. Serving the CEO definitely counts.
And timing matters. Rule 4 meters generally requires service within 90 days of filing the complaint. Need good cause for an extension.
Right, and oops, I forgot is not good cause. There's also waiver of service. Plaintiff can send a request to waive formal service.
Ah, the carrot and stick. If the defendant waives, they get longer to answer 60 days instead of 21, or 90 if foreign.
But if they refuse to waive without a good reason, they usually have to pay the costs of making formal service happen.
Okay. Jurisdiction and service done. Now venue. The right federal district. Just because a state has PJ and SMJ doesn't mean every federal court in that state is the right venue.
Correct. 28 U.S.C. Section 1391 lays out the main rules. Venue is proper in a district where any defendant resides if all defendants reside in the same state.
Or
a district where a substantial part of the events or omissions giving rise to the claim occurred, or where the property that's the subject of the action is located.
And if neither of those works,
then basically any district where any defendant is subject to personal jurisdiction. That's the fallback.
Residency for venue,
Yeah.
individuals, it's domicile again, corporations, it's any district where they're subject to PJ.
Angela's notes also mention forum selection clauses, contract terms, saying where suits must be brought. Federal courts generally enforce these using the transfer statute, Section 1404, applying federal standards.
Speaking of transfer, Section 1404 lets a court move a case from one proper federal venue to another proper federal venue where it could have been brought initially for convenience, interests of justice.
Right. The example from the notes, accident in State B, plaintiff sues in their home State A, if venue PJ okay there. Defendant might move to transfer to State B if it's more convenient for witnesses, evidence, etc., assuming State B also works for venue and PJ.
And if the better forum isn't another U.S. federal court but maybe a foreign country, then it's not transfer, it's forum non-convenience, FNC.
Exactly. The court dismisses the case because another court system, usually foreign, is available and adequate, and the current forum is just too inconvenient. Factors include access to proof, witness availability, local interest. It's rare if the plaintiff is suing in their home forum. Dismissal is usually conditioned on the defendant agreeing to jurisdiction and waiving defenses in the other court.
Last piece here, removal. 28 U.S.C. Section 1441. This is the defendant's power to move a case from state court to federal court. Key condition.
The case must be one that could have been filed in federal court originally, so it needs federal question or diversity SMJ.
It gets removed to the federal district court that geographically embraces the state court where it was filed. All served defendants generally have to agree to remove.
And the big limitation, especially for diversity. If removal is based only on diversity, it's barred if any defendant is a citizen of the state where the suit was filed, the in-state defendant rule.
Defendants have 30 days to remove after getting the pleading that shows the case is removable. There's a 1-year limit for diversity removals unless the plaintiff acted in bad faith to prevent it. And importantly, venue is automatically proper in the removing federal court. You don't reanalyze Section 1391.
Okay, that covers getting into the right federal court. Now, once you're there, especially in a diversity case, what law does the court apply, state or federal?
The Erie Doctrine, the classic rule. Federal courts in diversity apply state substantive law and federal procedural law. Easy to say.
Harder to apply. Figuring out substantive versus procedural is the trick. The notes mention the outcome determinative test from Guarantee Trust. If applying federal procedure instead of state procedure would significantly affect the outcome, potentially encouraging forum shopping, the court might have to apply the state rule.
What if there's a federal rule of civil procedure directly on point?
Then things get interesting. If an FRCP is on point, constitutional, and valid under the Rules Enabling Act, it generally controls, even if it conflicts with state law. Supremacy Clause. Angela's notes give the example of federal relation-backed rules for amendments trumping state law.
So FRCP usually wins if it applies. What about areas where there's no specific rule or statute? Can federal courts just make up law?
Sometimes, yes. Limited federal common law exists, or federal courts might adopt state law as the rule of decision to fill gaps in federal statutes, especially where national uniformity is needed. Think interpreting terms in federal laws or figuring out lien priorities under federal programs.
And preclusion. If you have a judgment from one court, what law determines its effect in a second lawsuit?
The second court applies the preclusion law of the system that rendered the first judgment. So, if the first case was in California state court, a federal court later looks to California preclusion law. If the first case was in federal court based on diversity, the rule from Semtec says the second federal court generally applies the preclusion law of the state where the first federal court sat.
Okay.
Kind of circular.
Okay. Law applied. Sorted. Now let's get into the nitty-gritty of pretrial procedures. This is where most cases live and die.
Absolutely. Starts with the pleadings. In federal court, it's notice pleading. The complaint needs a short, plain statement showing you're entitled to relief. Enough facts to make the claim plausible, not just conceivable. Plus the basis for SMJ and what you want, the relief.
Plausible, like the Twombly-Iqbal standard, more than just saying defendant wronged me.
Right. And courts are a bit easier on pro se folks, but the basics still apply. The defendant responds with an answer.
Admit, deny, or say you don't know. And admissions are binding. Can't argue otherwise later. Gotta raise affirmative defenses too, or risk waiving them.
Timing. Answer usually due 21 days after service. 60 days if service waived, 90 if foreign. But if you file a Rule 12 motion first, the clock pauses until the court rules, then you get 14 days.
Okay, Rule 11, the conduct rule, applies to signed papers, pleadings, motions, not discovery stuff.
Yeah, by signing, the attorney or pro se party certifies they made a reasonable inquiry, it's not for improper purpose, the law supports it, or a non-frivolous argument to change it. The facts have support, or will likely get support after discovery, and denials are warranted.
Violations can mean sanctions, money, striking things, and the crucial part, the 21-day safe harbor.
Absolutely key. You have to serve the motion on the other side first, give them 21 days to fix the problem. If they withdraw or correct the paper, you cannot file the motion with the court. It forces you to try and resolve it informally first.
What if you need to change your pleading? Rule 15 amendments.
You get one amendment, as of right, early on within 21 days of serving it, or 21 days after getting a response, or Rule 12 motion. Quick fix window.
After that, need the other side's consent or the court's leave. And the standard is freely give leave when justice requires. Pretty generous.
Usually granted unless there's undue delay, bad faith, prejudice to the opponent. And relation back is important for statute of limitations.
Right. If the amendment adds a claim from the same transaction or occurrence, it relates back to the original filing date. Changing a party is harder.
Much harder. Same transaction plus the new party had to get notice within the Rule 4-meter service period, 90 days, and knew or should have known they were the intended defendant, but for a mistake in identity. Not for adding someone you just forgot about.
Okay, moving on to Joinder. Adding parties and claims, lots of rules here.
Rule 20, permissive joinder. Lets multiple plaintiffs join together or plaintiffs sue multiple defendants if the claims arise from the same transaction occurrence and share a common question of law or fact. It's about efficiency.
Then Rule 19, required joinder. These are parties the court says must be joined if possible. Necessary parties.
Right. Someone's required if the court can't give complete relief without them, or if their absence would impair their own interest, or leave existing parties at risk of double or inconsistent obligations.
But what if joining them isn't feasible? Like, it destroys diversity.
Then the court has a tough choice. Look at factors. Prejudice to the absentee or parties. Can relief be shaped to lessen prejudice? Would judgment without them be adequate? Does plaintiff have another forum like state court? If the party is truly indispensable, the case might get dismissed.
Okay. Counterclaims, Rule 13. Claims back against your opponent.
Compulsory counterclaims arise from the same transaction occurrence as the main claim. You must raise it in your answer, or you lose it forever. Usually gets supplemental jurisdiction.
Permissive counterclaims don't arise from the same transaction. You can raise it, but don't have to. Needs its own SMJ basis, FQ, or diversity.
Cross claims, Rule 13G. Claims between co-parties like D1 versus D2 must arise from same transaction as the main suit or counterclaim, never compulsory.
Rule 14, third-party practice or impleader. This is a defendant pulling in a new party, the third-party defendant, PPD.
Right. The defendant says, if I'm liable to the plaintiff, then this TPD is liable to me for all or part of it. Think indemnity or contribution. The original plaintiff can then assert claims against the TPD too if they arise from the same transaction. But watch out for those 1367B limits in diversity cases.
Rule 24, intervention. When an outsider wants in.
Intervention of defense.
Right. If they have an interest that might be impaired and isn't adequately represented by current parties. Permissive intervention is discretionary if their claim defense shares a common question with the main action. Court weighs delay and prejudice. Again, 1367B can limit supplemental jurisdiction here in diversity cases.
Last one, interpleader. Rule 22 or the statute. Stakeholder with property claimed by multiple people.
Lets the stakeholder deposit the property money with the court and force the claimants to fight it out. Statutory interpleader, Section 335, is often easier. Minimal diversity, $500 stake, nationwide service, venue where any claimant resides. Wow, that's a complex web of parties and claims. Okay, once that's sorted, discovery, the information exchange phase.
And it usually can't start until the parties have their Rule 26F conference. They have to meet, discuss the case, disclosures, discovery plan.
Scope is broad, anything non-privileged, relevant to a claim or defense, and proportional. Doesn't have to be admissible at trial.
Rule 26A, required disclosures are automatic. Initial disclosures, key people, key documents supporting your case, damage calculation, insurance info.
Then expert disclosures for testifying experts, their report, opinions, basis. Drafts and most attorney communications are protected work product, though.
And pretrial disclosures, 30 days before trial. Witness lists, deposition designations, exhibit lists. Opponent has 14 days to object to admissibility, except relevance prejudice.
The actual discovery devices. Depositions, oral Q&A under oath, limited to 10, 7 hours each usually. Interrogatories, written questions only to parties, limited to 25.
Requests for production, documents, ESI, things, inspection, only to parties unless you use a subpoena for non-parties. Request for admission. Ask opponent to admit facts authenticity, only parties. Failure to deny in 30 days is an admission.
And if someone doesn't cooperate, sanctions. Can range from paying costs to, in extreme cases, dismissal or default. Often need a motion to compel first.
Pretrial phase also involves case management. Scheduling orders set deadlines. Pretrial conferences narrow issues, push settlement. The final pretrial conference order basically replaces the pleadings and controls the trial. Very hard to amend.
What about emergency relief? Injunctions?
TROs, temporary restraining orders, are super short-term, maybe ex parte without notice. In emergencies, not usually appealable immediately. Preliminary injunctions last longer, pending trial, require notice in hearing, are immediately appealable. Both need specific findings and clear terms.
And getting out early. Voluntary dismissal by plaintiff, Rule 41A. Usually without prejudice, unless it's the second time they've dismissed the same claim by notice, the two-dismissal rule.
Involuntary dismissal, Rule 41B, is by the court, maybe for failure to prosecute or follow orders, usually on the merits. But some tech clarified that's for federal purposes. State law decides preclusive effect in later state suits.
Okay, if we survive all that. Trial. Seventh Amendment gives a right to a jury trial in federal court for suits at law, not equity.
If you want a jury, you must demand it in writing within 14 days of the last pleading on that issue. File with the court. Can't withdraw the demand without everyone's consent.
Federal juries, 6 to 12 members. Verdict usually needs to be unanimous, returned by at least 6. Parties can ask for polling.
Jury selection. Voir Dire. Batson challenges stop discriminatory strikes based on race or gender.
Jury instructions are key. You have to object specifically on the record to preserve errors for appeal. Unless
It's plain error. Obvious, substantial error affecting fundamental rights and fairness. High bar, but allows review even without objection.
Okay. Motions during and after trial. Rule 50. Judgment as a matter of law. JMOL. Formerly directed verdict.
Can move after opponent rests their case. Standard. Viewing evidence favorably to non-movement, could a reasonable jury not find for them?
After the verdict, you can file a renewed JML, RJML, Rule 50B, within 28 days of judgment.
Huge prerequisite. You must have made a JML motion at the close of all evidence before the jury deliberated. No prior JML, no RJML. Standard is the same. No reasonable jury could have reached this verdict.
If you didn't make the JML, or just want to do-over for other reasons, motion for new trial, Rule 59, also 28-day deadline.
Broader grounds here. Trial errors, misconduct, newly discovered evidence, verdict against the great weight of the evidence. Judge can weigh credibility a bit here, unlike JML.
And Rule 60B, relief from judgment, for things like mistake, fraud, 1-year limit, void judgment, no SMJ, satisfied judgment, or other extraordinary reasons, reasonable time limit.
Okay, verdicts and judgments. General verdict, jury just says who wins, how much. Special verdict, jury answers specific fact questions, judge applies law.
Default judgment, Rule 55, if defendant doesn't show up. Liability is set, but usually need a hearing for damages. Defendant needs notice if they appeared earlier.
Judgment on the merits is key for preclusion. Includes SJ, maybe default, some involuntary dismissals, not dismissals for lack of jurisdiction, venue, or required party per Sumtech Rule 41B interaction.
Which leads to preclusion. Claim preclusion, res judicata, bars relitigating claims that were or could have been raised, needs 1. Valid final judgment on merits. 2. Same parties or privies. 3. Same claim, same transaction occurrence. Compulsory counterclaims not raised are barred.
Issue preclusion, collateral estoppel, bars relitigating specific issues actually litigated, decided, and essential to the first judgment. Requirements, same issue. 2. Actually litigated. 3. Actually decided. 4. Essential to judgment.
Doesn't require strict mutuality. Non-parties can sometimes use it, non-mutual issue preclusion, but the party being estopped must have been in the first case and had a full chance to litigate the issue. Offensive non-mutual use might be denied if plaintiff could have joined easily.
Okay, final stage. Appealability and review. The bedrock is the final judgment rule, Section 1291. Generally, you can only appeal final judgments that end the whole case for everyone.
So, granting SJ is final, denying SJ, not final, not appealable yet, denying a motion to dismiss for lack of PJ, not final either, wait till the end.
But there are exceptions. Interlocutory appeals, Section 1292, for things like orders about injunctions or class certification orders, Rule 23F.
Rule 54B, certification. Judge can make a ruling on some claims parties final if there's no just reason for delay. Needs explanation.
Collateral order doctrine. For crucial issues separate from merits, effectively unreviewable later. Think immunity defenses.
When an appeal is heard, different standards of review apply. Questions of law, reviewed de novo. Appellate court decides fresh, no deference.
Findings of fact by a judge, reviewed for clear error. High deference, only reversed if firmly convinced of mistake. Give weight to credibility findings.
Discretionary rulings by the judge. Evidence, discovery, new trial motion. Reviewed for abuse of discretion. Did the judge act unreasonably or arbitrarily?
Jury verdicts. Reviewed under that RJML reasonable jury standard. And unpreserved errors. That tough plain error standard. And that's the grand tour of Civ Pro, thanks to Angela's notes. We covered a ton.
We really did. And you can absolutely see why students find Civ Pro so challenging. It's often called one of the toughest bar subjects.
Yeah, I mean, just look at what we discussed. First, the sheer volume of detailed rules. The FRCP, plus all those statutes in Title 28, Section 331, 1332, 1367, 1391, 1404, 1441. It's a lot of numbers, a lot of specifics.
And everything is so interconnected, you can't grasp supplemental jurisdiction without understanding SMJ and Joinder rules. RJML depends entirely on having made that earlier JML motion. Service affects PJ. It's like a web.
Plus, all the deadlines and waiver traps. Miss raising your PJ or venue defense in the first response. Gone. Forget the Rule 11 safe harbor. Ouch. Miss the JML timing. No RJML for you. These aren't just suggestions. They have teeth.
And the doctrines themselves have so many nuances. Specific versus general jurisdiction. That Grabble test for embedded FQ Erie analysis. Claim versus issue preclusion, especially non-mutual issue preclusion. It takes real effort to get the distinctions right.
Absolutely. And applying the different standards for motions, plausible facts for pleadings, no genuine issue of material fact for SJ, no legally sufficient evidence for JML. You need precision. Angela's notes, being so detailed with rules and examples, seem perfectly geared for that kind of exam prep rigor.
It's definitely not just about memorizing. You have to see how the pieces fit and apply them.
Exactly. Requires practice, practice, practice.
Well, this deep dive definitely covered those core pieces. We've successfully wrapped up our look at civil procedure using Angela's fantastic outline, from starting the suit all the way to appeal.
These really are the essential building blocks for understanding litigation and, yes, for tackling exams.
Agreed. And now, as planned, we close the book on Civ Pro for now. Our next deep dive will take us into a whole new area. Contracts.
Promises, breaches, consideration. Should be fun.
Looking forward to it. So as we wrap up Civ Pro, here's a final thought for you, the listener, to mull over. We just spent all this time talking about the incredible complexity of civil procedure, all the detailed rules, the strict deadlines, the jurisdictional layers, the motion practice intricacies. Why do you think the system evolved this way? What underlying goals or values is it trying to balance? Is it mainly about efficiency, fairness, finality, predictability, or is it a mix, a constant tension between competing ideals?
It's definitely a system shaped by history and competing priorities. Lots to think about there.
Indeed. Keep exploring those questions as you continue your studies. Thanks so much for joining us on this deep dive.
Until next time.
Hey, thanks for listening. And now that is a wrap on civil procedure. Yay, we've gotten through that. So one topic down, 13 more to go? Anyhow, thank you for tuning in. As always, AI isn't always correct. I'm not a lawyer. I'm not giving legal advice. Be safe when you're driving in your car. If you need to reach me, I'm at podcast@studyforthebarinyourcar.com. I also work as a law clerk. If you need freelance ad hoc legal help and you're an attorney, you can contact me at hello@legalwriterandlawclerk.com. Anyhow, thanks for tuning in, and we'll see you either on the bonus episode or you can hop over to the next season where we discuss contracts.